Um, every single year, millions of Americans sign a document that could, theoretically send them to federal prison for up to 3 years.
Yeah, it's pretty wild when you actually think about it.
Right. And you have almost certainly signed one yourself. I mean, it's just your standard U.S. income tax return.
Oh, yeah, everyone does it.
Exactly. Under Title 26, Section 6065 of the U.S. Code, when you sign that form, you are legally declaring that everything in it is true under penalty of perjury.
Which is a heavy phrase.
It is. You don't need a judge in a black robe. You don't need a wood-paneled courtroom, and you definitely don't need to put your hand on a Bible.
No, you really don't.
You are bound by these rules just by, participating in modern society. So, welcome to today's deep dive.
Glad to be here.
Our mission today is to really unpack a concept we've all seen in legal thrillers, but rarely understand in practice, which is perjury.
Yeah, the Hollywood version is very different from reality. Oh, totally. And we are pulling all our insights today from a single, incredibly comprehensive source. It's a massive, heavily detailed Wikipedia article that covers, the legal frameworks, the completely bizarre history, and the high-profile global cases surrounding this crime.
And what becomes immediately clear when you read through this material is that the courtroom oath isn't like a magical truth serum.
Right.
We tend to view perjury as this simple binary switch, like you either tell the truth or you're a liar.
Good guy, bad guy.
Exactly. But the actual legal machinery is wildly complex.
Yeah.
Perjury is actually much, much harder to commit than just telling a lie.
Okay, let's unpack this. Because if I tell a flat-out lie on a government form or while sitting in a witness box, what exactly separates that from federal crime?
Well, to understand that, you really have to look at the anatomy of the crime itself.
Okay.
Like most common law crimes, perjury requires two separate, simultaneous elements. You need the actus reus, which is the physical act of making the false statement.
The actual talking or writing part. Right, exactly. And you need the mens rea, which is the specific intention behind it.
So if I just get my facts wrong, even if it causes a huge problem, that isn't enough to trigger a charge.
Not at all. Honest mistakes, inaccurate recollections, or just drawing a terrible conclusion from a set of facts, none of those qualify.
Really?
Yeah. I mean, if you honestly believe what you are saying is true, or if you just have a genuinely terrible memory, you lack that mens rea. You lack the intent to deceive.
Okay, that makes sense.
But there's a third element that is just as crucial, and it's called materiality.
Right, the concept that the lie actually has to matter to the underlying case.
Yes, exactly.
Like I can put this into an everyday analogy for you listening. If I'm under oath in a courtroom, and I'm asked about my favorite color, and I say blue and it's actually red, that is not perjury.
No, because nobody cares.
Exactly. Nobody cares. It doesn't change the outcome of the trial at all. But if I lie about my age to qualify for early retirement benefits, that is perjury.
Because that specific lie directly influences a legal and financial result.
Right. It's material.
Exactly. The lie has to be material to the proceeding. But what's fascinating here is how courts have historically struggled to prove all of these elements at the same time.
I can imagine.
I mean, think about the burden of proof. How do you prove what is inside someone's head?
Yeah, that seems impossible.
Right. How do you prove they didn't just forget, but that they willfully chose to deceive the court? In the United States, the baseline for this was actually set by a seminal Supreme Court case called United States v. Dunnigan.
Now, I have to push back on this a bit because it really does sound impossible. Unless you have, an email where the person says, I'm going to lie on the stand today, how on earth does a prosecutor prove a mistake wasn't just a foggy memory?
It is incredibly difficult. And that's why perjury charges are relatively rare compared to how often people, probably lie in court.
Which is probably a lot.
Oh, absolutely. But the Dunnigan precedent established that the government has to prove the accused gave false testimony concerning a material matter with the willful intent to provide false testimony.
Willful intent?
Yes. It cannot merely be a result of confusion. Deliberation is totally required. However, the courts aren't completely helpless here either.
Right.
They've also established that you cannot just close your eyes to the truth to save yourself.
Meaning, willful ignorance isn't a get-out-of-jail-free card.
Precisely. If a prosecutor can prove that you purposefully avoided looking at your bank statements specifically so you could sit on the stand and say, I have no idea how much money is in that account.
Ah, I see.
Yeah, the courts can interpret that deliberate avoidance as the intent to deceive. You engineered your own ignorance.
Wow, okay. That makes sense. But if proving intent is this nuanced and difficult today, With all our modern legal precedents and our deep understanding of human psychology, how did courts handle this centuries
Oh, it
ago?
was completely different.
Like, how did a medieval judge figure out if a witness had mens rea?
That takes us into the truly bizarre history of English common law because, frankly, for a very long time, the legal system didn't even try to figure it out.
Really?
Yeah, they outsourced the problem entirely.
The history detailed in our source material completely blew my mind on this.
It's wild.
Going back to Anglo-Saxon legal procedure, early on, the only people who could even technically commit perjury were jurors and compurgators.
Which were basically character witnesses who just swore to a defendant's general innocence.
Right. And when actual factual witnesses, like people who actually saw the crime happen,
Yeah.
when they first started appearing in court, they were treated with absolute immunity.
Yes, they literally could not be charged with perjury.
Hey, you're telling me that for centuries, a witness could just get on the stand, tell a blatant, malicious lie that could result in an innocent person being locked away or even executed.
Yep.
And the legal system essentially shrugged and said, well, they took an oath, so it must be true. That sounds like a catastrophic structural flaw in the justice system.
Well, to our modern ears, yeah, it sounds insane. But if we connect this to the bigger picture of how society functioned back then, it makes a strange kind of sense.
Okay, how so?
The roles in the courtroom just hadn't fully evolved yet. The prevailing legal maxim at the time was literally that every witness's evidence on oath was true.
Because the oath itself wasn't just a legal formality, it was like a divine guarantee.
Exactly. You have to remember the intense religious context of the era. Swearing an oath was viewed as invoking a literal curse upon yourself.
Oh, wow.
The belief was that if you lied after swearing to God, you were damning your own immortal soul to hell.
So the stakes were eternal.
Completely. The courts believed that the fear of eternal damnation was a far greater deterrent than any earthly prison sentence.
I mean, I guess that tracks for the time period.
Right. Therefore, if someone was willing to take the oath, the court assumed they were telling the truth because no rational person would risk hellfire over, a property dispute.
That is fascinating.
It wasn't until the 15th century that the infamous Star Chamber in England finally started punishing witnesses for lying.
So society essentially realized that people were, in fact, perfectly willing to risk eternal damnation to win a lawsuit.
Pretty much, yeah.
So in 1540, the English Parliament finally cracked down on subornation of perjury, which is inducing someone else to lie. And then in 1562, they started imposing monetary penalties for perjury itself.
But the punishments evolved to be far worse than just fines. Under common law, the penalties ranged from banishment to just absolute barbarism.
Visceral is the word for it. The text details punishments like physically severing the tongue of the perjurer.
Just gruesome.
So gruesome. And there's one specific case from 1732 that really paints a picture of how angry ordinary people were about this crime.
Oh, the John Waller case?
Yes. There was this British highwayman named John Waller. He was caught lying and sentenced to the pillory, locked in the wooden stocks in the public square.
Right.
But the crowd was so deeply enraged by his lies that they essentially pelted him to death.
They did.
He died while being punished for perjury, literally killed by an angry mob.
Which really highlights something fundamental about human nature, I think. Lying under oath isn't just an offense against another person.
What is it then?
It's a corruption of the communal system we all rely on to maintain order. If the justice system is a suspension bridge, perjury isn't just a dented guardrail.
Right.
It's someone actively unscrewing the main bolts, holding the cables together. If the truth doesn't matter, the entire bridge collapses.
That is a great analogy.
And that deep philosophical view of the crime completely dictates how wildly different countries penalize it today.
Yeah, if a mob killing a guy in a pillory shows how seriously the public took it in 1732, the modern global stakes show that the legal system takes it just as seriously today.
Oh, absolutely.
The baselines are strict enough. In the U.S., under federal law, it's a felony with up to 5 years in prison. In the UK, it's up to 7 years. In Canada, it's an indictable offense with a maximum of 14 years.
But those are just the starting points.
Right.
Look at Australia and New Zealand. In several jurisdictions there, the penalties double, going up to 14 years or even life imprisonment if the perjury was committed specifically to wrongly convict someone of a serious offense.
And then you have California.
Yet, California is a whole other level.
Under the California Penal Code, if your perjury causes the wrongful execution of another person, your lie can be construed as murder or attempted murder,
It becomes a capital offense.
meaning you could face the death penalty simply for lying on the stand. It's literally a matter of life or death. The lie is treated as the murder weapon.
Exactly. But contrast that extreme, highly punitive approach with a system like India's, where the underlying philosophy takes a totally different, almost bureaucratic turn.
Okay, how so?
Under the Indian Penal Code, perjury is fundamentally described as muted.
Muted. That's an interesting word for it. This is due to Section 195 of their Code of Criminal Procedure, right?
Yes.
And to translate the dense legal phrasing here for you listening, the rule states that a court cannot take cognizance of a perjury offense unless the complaint is made in writing by the court itself. And taking cognizance basically means the legal system formally acknowledging the crime. So let me get this straight. If I'm in a bitter civil dispute with my neighbor in India, and I have absolute proof my neighbor just lied on the stand, I can't just call the police and file a perjury report against them.
Correct. You, as the private citizen, cannot initiate that complaint.
Wow.
Section 195 restricts police or prosecutors from just acting on your accusation. The judge who presided over the case, or a superior court, has to be the one to formally file the complaint in writing.
But why create that massive bottleneck? That seems counterintuitive.
Well, because it answers a vital philosophical question: who is the actual victim of perjury?
Oh, I see.
In the Indian legal framework, perjury is not viewed as a personal injury against the opposing party. It is fundamentally an administrative crime against the justice system itself.
It is an attempt to usurp the power of the courts.
Exactly. Because the court was the entity that was lied to, the court itself must be the entity to recognize the offense and seek prosecution.
That actually makes a lot of sense.
Yeah, it stops people from using perjury accusations as a weapon to harass their rivals after a lawsuit ends.
That is a brilliant way to prevent a never-ending cycle of lawsuits.
It really is.
But, knowing that these penalties exist globally, from years in prison to life behind bars to potentially execution in California, it completely makes sense that smart people and their very expensive defense attorneys have spent decades finding ways to navigate around the strict legal definition of this crime.
Oh, absolutely. Which brings us to the loopholes.
The loopholes.
Because the law requires both absolute falsehood and clear intent, the defenses against perjury can be incredibly precise, almost like linguistic gymnastics.
The most famous example of this in the U.S. is the Braunston precedent, right?
Yes, exactly.
The Supreme Court ruled that statements that are literally true or answers to truly ambiguous questions cannot be considered perjury, even if they are deeply intentionally misleading.
It's all about literal truth.
Here's where it gets really interesting. Imagine you were pulled over for speeding on a Tuesday. The officer asks, "Were you speeding today?" And you respond, "I always drive the speed limit on Mondays."
That is a perfect example of this.
Right. You might actually drive the speed limit on Mondays.
Right.
That statement is a literal truth, but it is totally evasive regarding what you did on Tuesday.
Completely evasive.
According to the Braunston framework, because your statement about Monday was factually, literally true, you haven't committed perjury, even though your entire goal was to mislead the officer about Tuesday.
Yeah. And the Supreme Court's logic here is actually quite strict on the lawyers themselves. Their view is that it is the opposing lawyer's job to ask precise questions and demand precise answers. If a witness gives an evasive but literally true answer, the lawyer needs to follow up and pin them down. It is not the court's job to criminalize clever evasions if the examining attorney fails to do their job.
That is wild. But prosecutors eventually got tired of people slipping through that literal truth loophole, didn't they?
Oh, definitely.
So Congress expanded the prosecutor's toolkit by introducing Section 1623 of the United States Code. And this covers mutually incompatible statements.
Right. Under Section 1623, the government realized it was just too hard to prove exactly which statement was the lie.
Because they'd have to prove the underlying fact.
Exactly. So now they don't have to. If you make two statements under oath that are so completely incompatible that at least one of them must necessarily be false, that contradiction alone is enough for an indictment.
So if I swear on Monday the light was red, and then swear on Tuesday the light was green.
The prosecutor doesn't have to prove the actual color of the light. The impossible contradiction is the crime.
It's essentially trapping you in your own logic.
Pretty much.
But there's also a fascinating defense built into the U.S. system, designed to encourage people to eventually do the right thing, which is the defense of recantation.
Yeah, this is an interesting one.
If you get on the stand, tell a lie, but then get cold feet and admit you lied during that exact same proceeding, you can sometimes save yourself from prosecution. It proves that the ultimate goal of the system is to get to the reliable facts, not just to punish people.
Ideally, yes, the goal should be truth, but the reality of how the law is applied can be much darker. And this is where we get into the highly controversial perjury trap.
Which sounded completely like entrapment when I was reading it.
It walks a very fine line. A perjury trap is a specific tactic where a prosecutor calls a witness to testify before a grand jury, not because they're genuinely trying to gather facts to solve an underlying crime, but explicitly hoping to draw a perjurious statement out of that specific witness.
So they ask questions they already possess the answers to.
Exactly. They have the documents, they know the truth, but they ask the witness anyway, hoping the witness will lie to protect themselves or someone else.
Wow.
If the witness lies, the prosecutor suddenly has a clean, easy perjury conviction, even if they never had enough evidence to charge anyone for the original crime they were investigating.
That is intense. And to see how these traps, these literal truth loopholes, and these incredibly strict definitions play out in reality, we really just have to look at the rogues gallery of notable figures accused or convicted of this crime.
Yeah, it's a long list.
It proves that no amount of wealth, fame, or status makes you immune to the mechanics of the law. Let's look at some of the convictions. You have elite athletes, like American track and field star Marion Jones, who was sentenced to 6 months in prison in 2008 for 2 counts of perjury.
Right.
You have musicians, like the rapper Lil' Kim, who received a year and a day for lying to a grand jury about a shooting outside a radio station.
You also see it heavily in the financial sector. Bernie Madoff was found guilty of perjury in 2009 as part of the fallout from his massive Ponzi scheme.
Well, of course.
And crucially, it happens within the justice system itself. Former LAPD detective Mark Furman entered a no-contest plea to a perjury charge related to his testimony during the O.J. Simpson murder trial.
Yeah, our materials note that the Furman situation was one of the most seminal, high-profile occurrences of police perjury in modern history.
Definitely.
There is even a specific slang term for it within the legal community.
Testaling.
Testaling.
It's when officers stretch the truth, manipulate timelines, or outright lie on the stand specifically to ensure a conviction they feel is justified.
It's a huge issue.
But it's not just convictions that shake things up. The mere allegation of perjury can alter the course of history, especially at the highest levels of government.
And you see this constantly across the entire political spectrum.
Absolutely. And, looking at our sources, we have to just report the facts neutrally here. Former President Bill Clinton was accused of perjury in 1998, which was the direct catalyst for his impeachment by the House of Representatives.
Right.
While no criminal charges were ultimately brought, he accepted an immunity deal upon leaving office that included a suspension of his law license.
And on the other side of the aisle, exactly.
Yeah.
Similarly, Louis Scooter Libby, a high-ranking official in the George W. Bush administration, was convicted of perjury and obstruction of justice in connection with the Plame affair.
You also see these allegations frequently aimed at the intelligence sector.
Oh, for sure.
Michael Hayden, former CIA director, faced heavy scrutiny and accusations of lying to Congress in 2007 regarding enhanced interrogation techniques.
And there was James Clapper, too.
Right. James Clapper, the former director of national intelligence, faced intense public accusations of perjury after telling a congressional committee in 2013 that the NSA did not collect data on millions of Americans.
A statement that was later contradicted by massive intelligence leaks.
Exactly.
But just as the allegations can ruin a career, those precise loopholes we discussed earlier can save one. Take Andy Coulson, a British journalist and political aide.
Oh, the phone hacking scandal.
Yes, he was completely cleared of perjury charges stemming from the News International phone hacking scandal. Why? Specifically because the Scottish court ruled his false testimony was immaterial.
Wow. Immaterial.
Even though he lied, the lie didn't meet that strict materiality requirement to be considered perjury under the law.
Which goes to show how vital that three-part anatomy of the crime really is.
Absolutely.
But there's one more layer that high-profile figures, corporate executives, and powerful people often fall victim to, and that is subornation.
Right. We mentioned that briefly earlier.
Under 18 U.S.C. Section 1622 in the U.S., subornation of perjury which is the act of inducing someone else to lie, carries the exact same weight and potential prison time as committing perjury yourself.
So a CEO can't just tell their assistant to go take the fall on the witness stand.
Exactly. For powerful individuals, having an underling lie for them is just as criminally dangerous as taking the oath and lying themselves.
That makes total sense.
The prosecutor just has to prove that you positively induced the false testimony and that you knew the statement the person was going to make was false.
So we've traveled from ancient Anglo-Saxon courts, where witnesses were immune from prosecution because of the fear of divine wrath, to the brutal mob justice of the pillory, to California's modern death penalty stakes, to the nuanced, literally true loopholes navigated by highly paid defense attorneys.
It's quite the journey.
We've seen that perjury is so much more than just telling a fib. It's a deliberate, material deception, accompanied by willful intent that threatens the foundational structure of the justice system.
It really is the ultimate crime against the process of finding the truth. If the courts cannot trust the evidence presented to them, the entire mechanism of justice grinds to a halt.
So what does this all mean for you, the person listening right now? The next time you're filling out a government form, or you click I agree on a digital legal document, or you sign your income taxes in April, remember the anatomy of this crime.
Definitely keep it in mind.
You don't need a judge in a black robe looking down at you from a bench to be held to the highest standard of the law. The mechanism of perjury and the expectation of absolute material truth is woven into the fabric of everything we do.
It is everywhere. And, examining all of this leaves us with an important, almost uncomfortable philosophical question to consider regarding the balance of power in our legal system.
Oh, I know where you're going with this.
We discussed the perjury trap earlier, where a prosecutor intentionally maneuvers a witness into lying, not to solve a crime, but simply to charge them with the manufactured crime of perjury.
It's a total paradox.
It is.
Because if the entire underlying purpose of the justice system, from the ancient oaths to modern evidence law, is to uncover the truth, is it ever ethical for that same system to intentionally manufacture a crime of deception?
Exactly.
If the courtroom oath is supposed to be society's perfect filter for the truth, what happens when the government uses that filter as a weapon? Something for you to chew on long after the audio stops playing.